Hi, everybody. Good morning. Now, about a month ago, we were talking about the Fourth Amendment. Oh, and welcome to another constitutional talk. So, where I was at was we were discussing the Fourth Amendment about a month ago, and it's the first in a series of amendments on the rights of the accused. The fourth gets into being secure in your papers affecting your persons and that kind of thing. That you have to have a warrant and all that. And that's the initial response that law enforcement would have if they were investigating a crime. So if they're investigating the crime and they think you did it, then they have to swear out a warrant. A judge has to approve it, that kind of thing. But we're going to move today on to the Fifth Amendment. Now, a lot of times people plead what they call is pleading the fifth. I plead the fifth, officer. And it's the right against self-incrimination, so you don't have to talk. You can't be forced in a court of law to be a witness against yourself. You don't have to take a stand. You can, and there are cases where you might want to, but it's not necessary. But what you can't do is you can't take the stand and then refuse to be cross-examined by the prosecution, because once you do speak, you've given up that right against self-incrimination. You've given up the right to remain quiet. There's a lot more in the Fifth Amendment. Okay, no person shall be held to answer for a capital or other infamous crime unless on the presentment or indictment of a grand jury, which means a grand jury has to be seated and they have to decide, and generally they're deciding on, is there enough evidence to proceed. Okay, if there's not enough evidence to proceed, they aren't going to go along with the complaint. And the district attorney will not prosecute the crime in that case because there's just not enough evidence. Okay, there is an exception, however, and that exception is in a case arising in the land or in naval or in the militia, when an actual service during the time of war or public danger. So if you're on a battlefield and somebody has charged you with something, then it's not going to go to your civil courts. So therefore, you won't have a grand jury panel. What you'll have is a military tribunal that will try the case. And the same is in a case of national emergency, or what they call is public danger. And I think what they're really referring to is, say, a hurricane went through a fire or something, and you have looters running around, that kind of thing. And I think that would be your case of public danger. Or, per se, if you had an invasion, say, coming up from the south, through Mexico or something like that, where it could be a situation of public danger. There's a lot more than just those two items. Nor shall any person be subject to the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against yourself, nor be deprived of life, liberty, or property without due process of law. What we're talking about here is you can't be tried twice. That's what double jeopardy is. It's what they call double jeopardy, even though they don't use the term in the constitutional context. But the double jeopardy can't be used. So they cannot try you in a court, and then because they lose, they try you again with another jury. Well, that can't occur. That doesn't mean you can't appeal a case up, and you could appeal it to the next highest court. But that's a little different than being tried twice for the same offense. So that they can't do. It's another one of our rights of the accused. And then finally, we get to the section at the very end. Nor shall private property be taken for public use without just compensation. Okay, so they could take your property, but for what purpose? What reason would they take it? Well, sometimes they take it because they're turning a 2-lane highway into a 4-lane highway, and they need that space where there's a bunch of homes there. So, in order for the public good to expand the highway, they're going to take that property. And you have a right to a fair market value. It doesn't say fair market value, it says just compensation. But in today's world, that's what we're really talking about, that you get a fair market value for your property. Now, there have been times where property was seized for the public good that had nothing to do with those kind of things, or maybe they wanted a fire station or a police station, so they had to take the whole block. That all falls under the first example. But like after the Civil War, they took Lee's property and they turned it into a national cemetery, and he was never allowed back. They had taken his property for the public good to bury soldiers that had died due to the South leaving and attacking the United States then, and beginning the conflict we know as the Southern War, or the Civil War. And so that was taken for that reason. But they cannot take property for the public good without a just compensation for that property. Now, in the situation I just said, I mean, he wasn't reimbursed, but it was no longer American soil at that point because it was taken at the end of the war for burial with the idea that it was not a state at that time. It was a territory. So they took this land for that purpose. The rights of the accused are important. And as we move on from the Fourth and Fifth Amendments and we get into a right of a speedy trial, and you get into the right of trial by jury, and these kind of things, they all kind of together, they give us the rights of the accused. So if you're accused of something that you may not have done, you have a real shot at getting out of whatever trouble you're in. When we were governed under England, and you were arrested for a crime, you were charged with something, you had to prove yourself innocent. So we've gone the other way. We are presumed innocent until proven guilty. And justice is blind and all that. It doesn't say justice is blind, and it doesn't say presumed innocent until proven guilty. But that's in essence what we're doing here. They can't barge into your home without a warrant. They can't break down the door and seize things without a warrant. It has to be sworn out, and because you're secure in your papers, houses, facts, and all that. And then they can't run you over in court. They have to panel a grand jury in order to charge you for a serious offense. And they can't force you to testify against yourself. They can't take your property without just compensation. They can't try you twice for the same offense. These are all important rights, and it gets us away from the way we were governed under England. So with that, I hope you get a good grasp of this, and I hope you understand if we work through the rest of the amendments that have to do with the rights of the accused, I hope you get a clearer picture of exactly what we're talking about here. The third, Article 3 of our Constitution sets up a court system. They're trying to make a fair court system. You know, during the Constitutional Convention, one of the North Carolina delegates, Sprate, wrote back to the governor asking for more stipends because it was taking a lot longer. And the governor wrote back to him telling him that he wanted an independent judiciary. That's what he really was trying to get. And under Article 3, that's exactly what we do have. We have a Supreme Court, we have inferior courts set up below that. And so as you work up through the appeal process to the Supreme Court, there's lots of avenues there. There's lots of plateaus, per se, that have to be reached before you ever get to the Supreme Court. And in most cases start in the state courts, and then they're appealed to the federal level. And this independent court system is important. See, when you're arrested for something, by whether it's the local cops or the FBI, you know, all these steps have to take place. And this independent judiciary is important because the FBI and the cops, they aren't part of the legislative or executive branch. They're independent from the other. Sometimes people come to court and they complain about the law. You know, if you violated it and you can't prove, then they want to challenge the law. Well, a judge and jury don't really have anything to do with what the law is. They didn't write the law. That's for the legislative and the executive branches. That's why we have separation of powers. And then you have an independent judiciary that's not connected with law enforcement, that has to make the ultimate decision. And that's what's really important here, is the independent judiciary. And that's what helps, based with the rights of the accused, and the prosecution forced to find a way to show that you're guilty. They have to prove that you're guilty. And that's what's really important here. And I hope you take something from that. I hope you get to really understand what we're talking about here. And I'll catch you next time on the next Constitutional Talk. You have a good day now. Bye.